Good morning, everyone. We're just going to wait for a few seconds to allow some more people to join. I can see the numbers ticking up on the screen. So we'll start in about a minute or so, but welcome. Okay, the numbers are slowing a little bit, still ticking up slightly. So we'll just give it another about 15 seconds and then we will make a start. Okay, they seem to have plateaued. Oh, still just ticked over the 100. Okay, shall we make a start? So, good morning and welcome everyone to what is, I think, our last employment webinar of 2025. Before we get into the detail, I just got the usual housekeeping announcements in relation to if you have any technical issues this morning, then please do check your Zoom settings in the Zoom banner. And if you need help, please put a message in the chat box function, or as I sometimes do with most IT problems, sometimes if you quit and reconnect, that seems to sort out the problem. Hopefully, though, you can hear us this morning. We will take some questions at the end. So if, as we're speaking, you have questions, then please can you put them in the Q&A box? Please don't put them in the chat box because we may miss them. But if you put them in the Q&A box, we will do our best to get to as many questions at the end of our session this morning. The webinar will be recorded and we will send you a copy of both the slides and the recording in the next few days. So let's make a start, shall we? I'm joined by my colleague Alice Reeve this morning, and we're going to give you a pretty high-level overview of basically sketching out a bit of your to-do list for 2026 with regards to things that will certainly be occupying us and we anticipate will also be occupying you as we go into the new year. And broadly, we're going to look at three areas: the employment rights bill changes that we think are coming in 2026. The grounds keep shifting, but we'll tell you about the most up-to-date position. Some notable cases in 2026 where we have decisions, but there are going to be further litigation in relation to them, and then some just wider developments on the horizon, which again we think you should have in your mind and just be thinking through. So, in relation to the first of those, I'm just going to take you through the latest on the Employment Rights Bill. Some of you may have joined us recently when we talked through the Employment Rights Bill in a bit more detail in relation to a previous webinar. And we outlined the position on that day, and then very shortly after that, it changed a little bit. So the government has changed some of the proposals in the last week, and mainly around the day one rights for unfair dismissal, the ping pong, as we talked about previously, between the Lords and the Commons was continuing, and the government, in an effort to try and push through the bill, has now made some last-minute amendments. And those amendments, which I'll talk to you through in a second, are going back to the Lords today. And if there are sufficient concessions and the Lords now approve the bill in its current form, then we may well have an act, as in it will get royal assent before Christmas. But if the Lords are still unhappy and want to propose further amendments, the ping pong will continue into the new year. But let's see where we get to by the end of today. So the position as of this morning, is that the main change, which you'll have seen in various headlines and in various articles, is that the government's made a bit of a U-turn on unfair dismissal rights. So it was its manifesto pledge that they would have day one unfair dismissal rights, but has essentially moved away from that position and basically reduced the qualifying period from 2 years down to 6 months is now what the draft bill says. So there will no longer be the initial period of employment that you'll have heard us speak about previously, when essentially there was going to be a statutory probationary period. That has now fallen away as part of these latest proposals. And hopefully it has helped to resolve the ping pong with regard to the House of Lords position and the Commons. But yes, it is a fairly significant change. The other part of the change, as well as therefore going for a 6 months qualifying period for unfair dismissal, is that there was some discussion as to whether the government would do that and then do some further consultation with a view to bringing it down to zero and basically allow business more time and employers more time to manage the transition. But they have also committed, as part of the various consultations they've been doing in the background, that if they're going to change the qualifying period again, it will have to be done by primary legislation. So it seems that we would therefore have some certainty that the qualifying period for unfair dismissal will be 6 months once this comes into effect. In relation to, clearly they were trying to keep lots of stakeholders happy and get them on side. They have also committed to the change taking effect from the 1st of January 2027. And it will apply immediately to all employees is the latest indication. So essentially, it will therefore be something that appears on your to-do list in 2026 as the first, those recruited from July onwards are going to be able to rely on the right if there is then a dismissal at the end of their first 6 months. So, and it will apply to everyone. So essentially, those that you're recruiting going forward, they will have a shorter qualifying period in order to challenge any dismissal if that's where you find yourselves. So that's probably the most significant change, and obviously one which we'll be working through in relation to how that impacts potentially on recruitment policies, how you manage your probationary periods. I mean, a lot of employers have a 6-month probationary period. Is that still sensible? Do you want to make a decision before the expiry of the 6-month period? So employers may well be wanting to review those, and also ensuring that managers are equipped to be able to deal with performance early on in the working relationship to ensure that people get off to a good start, and hopefully it's a long-lasting employment relationship. But if there are problems, that they're properly documented and there are ways of being able to deal with the issues if they then need to be defended in due course. One of the other concessions which has taken quite a few people by surprise is in relation to the cap on unfair dismissal claims. So the government has now proposed, again, I think as part of this bundle of compromises to try and get this bill through, that the unfair dismissal statutory compensation cap, which is currently £118,233, will be removed. So they're going to repeal the section in the 1996 Employment Rights Act that means there will be no longer a statutory limit on the amount that tribunals can award for unfair dismissal. That will therefore bring the unfair dismissal legislation in line with what we know is the compensation territory in discrimination claims and whistleblowing claims. So the key difference being that those will still have an injury to feelings award and unfair dismissal won't. So the basis upon which compensation is assessed will still be the same. It's still in section 123 in relation to what is just and equitable in all the circumstances, looking at an employee's losses, both up to the date of a decision and any future losses. So again, potentially it's going to change the landscape in relation to dealing with the challenges to dismissal, employee expectations if they seek to bring a claim, and it may well help stop some of what we see around people who have had less than 2 years service or otherwise looking to enhance their negotiating position in relation to a claim by alleging whistleblowing or alleging discrimination, and we all know how complex and involved those cases can be. And there is some hope, I think, from the government that some of these changes will simplify the process. So if someone is asserting unfair dismissal, then that's what they will assert, and won't be looking to bring in other areas of litigation to make the litigation more complex, because they can potentially achieve some of their aims with this lift in compensation. Obviously, that may well also mean that managing dismissals day to day, whether they're for performance, redundancy, etc., may well become slightly more complex. Employees may hold out for more. And in those serious cases where something has gone wrong, you can see compensation limit claims obviously being much larger for those who are high earners, those who may have substantial pension entitlements or share option entitlements that can fall within compensation, and those who choose to pursue a claim for career loss, arguing that the dismissal has brought their career in their chosen area to an end. So I think an area where that we're going to see quite a lot of change and quite a lot of discussion. So those are the two that deal with dismissal. The next section is in relation to consultation on reference periods for guaranteed hours for those who are 0 hours workers. And you'll recall that the bill introduces a requirement for employers to make guaranteed hours offers for 0 hours and low hours workers. The way in which it works is that employers have to monitor the amount of hours worked over a reference period, and then write to a worker offering them guaranteed hours which reflect that reference period, if they then continue to work with the employer. The reference period initially is 12 weeks and then will constantly renew on a rolling 12-week basis. And we've talked previously about the administrative burden that potentially is going to create for those of you who have 0 hours workers on your books and want that flexibility in relation to how you manage your organization. At the moment, the only way to opt out of the requirements in relation to the 0 hours is to have a collective agreement in place, and obviously that's therefore pushing some of the government's trade union and collective agenda as well. The Lords, this is one of the areas of ping pong, have previously requested an ability for 0 hours workers to be able to opt out of the requirement for employers to make a guaranteed hours offering. And the government so far has rejected that and has continued to reject it, so has sent it back to the Lords rejecting that amendment. But they have instead made a commitment to consult on the length of the initial reference period, and also whether each subsequent reference period should, when they should begin and end, and whether you can have statutory areas, sort of set times, which would allow potentially to have processes in place that are slightly easier, rather than looking at each individual case, which is what's going to cause the administrative burden. So I think the suggestion the government may well seek to compromise further in order to get this legislation through. Sticking with the 0 hours commitments, obviously there is an impact on seasonal workers, and the House of Lords have wanted to include a statutory definition of seasonal workers so that they could then see legislation being made to basically deal with what the predictable fluctuations in labour demand that happen from time to time. Again, the government hasn't agreed with that. They've pushed back on that amendment, but they have again proposed to consult in respect of the interests of seasonal workers and agency workers and hirers before making regulations. So I think we could probably expect some fairly early consultation in due course. So the final area is then in relation to union ballots. And the bill currently removes the thresholds in relation to a ballot in favour of industrial action, which requires the support of at least 50% of those eligible to vote. The Lords have wished to maintain those thresholds and have therefore been pushing back. The government has now committed to only removing threshold after the Secretary of State has considered the effect of non-postal balloting and laid before Parliament a statement detailing how they see this playing out and how it would work. So essentially, I think this means that the 50% turnout rule will remain in place for the time being until the Secretary of State lays a statement before Parliament. So that's currently where we are with the main changes in the Employment Rights Bill, and we all wait to see how the House of Lords responds to those today, and whether we are able to move forward. But what does this all mean in relation to 2026? So Alice is just going to take us through how we might prepare for this change.
Brilliant. Thanks, Gareth. Yes, and we're working on the assumption that the changes that we're going to see are really as currently set out in the bill, subject to those tweaks that Gareth has mentioned, and that the implementation plan, which was published in July, will largely remain unaffected. Obviously, if there's any slippage, we'll let you know, but better to be on the front foot. And we thought it helpful, as Gareth said, to just reflect, given that this is our last webinar of 2025, on what all our collective to-do lists might look like in 2026. And so the main changes we're going to see as employment lawyers and HR practitioners all come out of the bill. We've picked a few of the key ones that I'm just going to talk to, and then look at what we think you need to be doing in order to be prepared for those changes. It isn't a comprehensive list. For those of you who want all the detail, I think you will, most of you will hopefully have saved our tracker previously, but it's there on the slide, which we keep up to date, and has the detail. And we have also got a number of recorded webinars, including the one last month, that looked at each of the changes in a little bit more depth. But for now, the purpose is just to give you a heads up on those changes that are now fast approaching. And so April 2026 will be here before we know it. And the main changes are still some rights that will be day one rights that haven't changed. To currently, both paternity and parental leave have qualifying periods of service, and that is being removed. And so all eligible parents will be entitled to those from day one of their employment. We're also going to see an extension to statutory sick pay. So currently, for those of you who operate the statutory regime, where there are the 3 waiting days before the entitlement kicks in on the 4th day of any absence, that is going. And so again, from day one, individuals will be entitled to receive statutory sick pay. We're also going to see a removal of the lower earnings limit to be entitled to statutory sick pay. And so again, low earners will be eligible to receive SSP, albeit it's likely to be at a lower level for those based on their actual earnings. We're also, in this first raft of changes, going to see the additional penalties introduced in relation to undertaking collective redundancies. So most of you should be aware that where there are 20 or more employees at risk of redundancy in a 90-day period, then there's a requirement to collectively consult with the staff representatives, which can be union reps or nominated employee reps. And failure to do that is both an unfair dismissal, but also leads to a protected award. Currently, up to 90 days' pay for each affected member of staff, but from April, that will be doubled to 180 days' pay per employee. And so given that we're talking about situations where 20 or more people are affected, it's important to be aware of that. I'm sure all of you try and be compliant, but it definitely ups the ante in terms of getting that right. One of the other interesting aspects of this is what triggers that requirement when it is the 20 or more. At the moment, that's at each separate establishment. So for those of you who are part of a big organisation, a group, you can still look at each operating unit. There was some discussion about whether that would go and it would be organisation wide, which would be a really significant change. But we're still currently operating on the basis of each establishment. But there has been a suggestion that there will be another threshold test introduced. So the requirement to collectively consult would either be, where there are 20 or more at each establishment, or where, you're looking at some other number across the whole organisation. If that's introduced, and that may be an April change or may come later, then obviously as an organisation, you're going to have to significantly look at how you keep track of the number of redundancies across your organisation. So it's still worth raising awareness about that now. we then move, so they're the April changes. I'm going to look at what you should be doing to prepare for these in a moment. But then moving slightly further on into later into the year, into autumn, October 2026, we see some of the perhaps more significant immediate changes under the Employment Rights Bill beginning to come into play. The first one on the slide there refers to trade unions. Actually, the increase in trade union profile in workplaces and the additional powers given to trade unions, making it easier for them to obtain recognition, making it easier for them to organise strike action, and having greater profile amongst your workforce is something that's one of the main themes of the Employment Rights Bill, and we see all the way through the implementation plan and timeline. But we picked out just in October, perhaps one of the slightly more controversial changes, or that has provoked the most questions of our team, which relates to the proactive duty to give unions the right to access workplaces in order to speak to your members of staff, to talk to them about the support that they can offer, to organise them and to engage in that way. They will be able to ask to come in, probably on a couple of days' notice, possibly once a week. And if you don't agree, then there is a formal route through the Central Arbitration Committee in which a formal access agreement can be imposed. So at the moment, employers are able to control how they engage with trade unions and their access to the workplaces. Those who've got recognised unions do that through the form of an agreed recognition agreement, but this for the first time will mean that that choice is taken out of employers' hands. One of the other big themes we wanted to mention is sexual harassment, and many of you will have been on the journey with us of this being a hot topic. And last year we saw the expansion so that employers have got this proactive duty to take reasonable steps to prevent sexual harassment in the workplace. Well, October 26, 2 years on, sees the next round of changes really relating to that, and the expansion to the duty to take all reasonable steps. And also a change that didn't make it through the first time round, the duty not only to protect harassment between colleagues, but also other third party, your staff from harassment by other third parties. So that's a significant change happening later in the year. And finally, the other biggie is the fact that the terminating employment contracts in order to rehire either the same staff or potentially different staff, or even agency workers on terms which are different, will be automatically unlawful. This, the scourge of fire and rehire is something that the government have made a significant noise about and wanting to make this unlawful. The law as it is slightly less is being restricted a little bit, but it's still really significant. So at the moment, if you've got terms and conditions or arrangements in place that don't meet the needs of the organisation, you are able to, if you've got a sufficiently strong business ground, able to go through a lawful process to consult with staff, follow the ACAS code of practice on fire and rehire, and impose new changes to terms and conditions, but that will be automatically unfair from October 2026, where it relates to certain restricted variations, which are all the ones you may really want to make in relation to pay, pensions, holiday, time off work. It doesn't helpfully now affect restructurings or changes to job function. So we'll still be able to do that, even if that doesn't quite constitute a redundancy situation. So that's the sort of list of the most significant changes. On the next slide, I just wanted to think about what you might be able to do to prepare for these and what you need to be thinking about. Well, to start with, there are some relatively straightforward policy changes. So you definitely need to be planning and think about any updates to your policy. So obviously you'll need to change your paternity and parental leave policies. You may need to change your sickness policy depending on whether you currently make use of those waiting days or not. If you do, you might also want to think about how you manage absence in those early days, and for sporadic and intermittent absence, how do you keep that under control? How do staff need to notify you when they're unwell? Do they need to sign any form of declaration or certification? do you need to think about training your line managers in terms of managing absence to try and keep that under control? Hopefully you don't need to change your HR or finance system if people are off sick, but if you do, that's something that will need a bit of a lead-in time, so definitely get that on the agenda now. The other policy change talked about in relation to sexual harassment, there'll be a required change to your whistleblowing policy, because the disclosure of sexual harassment either to yourself or to somebody else in the workplace will from April qualify as a protected disclosure under whistleblowing legislation. So it would join the list of things that someone might disclose that could constitute whistleblowing. So you'll need to change your whistleblowing disclosure, whistleblowing policy. You'll also need to make sure that your anti-harassment policy is fully up to date. I hope that all of you have got a new policy or an updated good policy from last year, but if not, you definitely need to get that higher up your list, and it will need another review ahead of October. And again, you've probably all got steps and measures in place around harassment, thinking about the training that's available for all your staff, and also line managers, and thinking about risk assessments and high risk areas and how to review that and follow up. But you will need to continue to keep that on the agenda, and it's clear that it is not just something, sadly, that you can have a list and tick off and you've done it, that you will need to have an annual process, I think, at least, where you're reviewing things that have come up, looking at those risks. Do you need to make any tweaks? Continue to learn, continue to engage with your staff to make sure that you're in a workplace where you can genuinely say you've taken all reasonable steps to prevent harassment. The third party element is also going to be a challenge, so spend some time thinking about where you might engage with third parties. Look at standard terms for organisations that may come into your premises. Think about whether you have something on your website or an overarching sort of ethos or behaviour statement that you can point to, so that everybody in your community understands what behaviour is acceptable when they're working with you or part of your organisation. Contracts is an interesting one. Do you need to change contracts? It's a question we get asked quite a lot. Now, there's no doubt that we will see some changes that require you to update your contracts for new staff, including there will be a statement being explicit that they have the right to join a trade union. So you'll definitely need to make some amendments to your new model contracts. Whether or not you need to change your existing contracts, one of the areas you might want to think about is around the fact that you won't be able to bring contracts to an end in order to impose change anymore. So one option is to use the contract and the contractual terms so that any variation or flexibility is within the terms of that contract. So if you consider that you really do need to be able to change, for example, someone's pay, then, what is the reason for that? Should that be enshrined in their contracts now? Is there anything you can do about that? It's definitely worth asking the question and understanding whether you can build in some specific tailored variation clauses if there are particular situations which require flexibility. And understanding that in your operation is important. Linked to that, if you have got any projects on the horizon where fire and rehire will be necessary in order to get that through, well, you're up against a ticking clock, really. Consultation will need to start very early on in January in order that you can go through a process and make sure that you've got time to give notice for staff before October. So if that's something that's on your agenda, please do get in touch with one of the members of the team as well. And finally, just to think about trade union relations, mention that it's a really common theme. Understand if you've got recognition in place, who applies for, how old is that recognition agreement? We see some that are very dated. Is there a good moment to dust it off and update it and engage with unions about what, for example, access to the workplace might look like, and how you might work with them on some of these matters? So we finished off talking about the Employment Rights Bill. And we're happy, obviously, to answer any questions in the Q&A. But we thought we'd move on and have a look at three particular notable cases that we're going to see in 2026. So just to give Gareth a little bit of time to join us, we're going to start in reverse, if that's all right with all of you. And I'm going to tell you a little bit about the last case, Dobson and North Cumbria NHS Trust. This is a really interesting case involving flexible working, which is another area we're going to see an expansion on. So Mrs. Dobson was a community nurse and she worked a fixed 2 days a week. And she had significant responsibilities out of work. She had childcare for 3 children, 2 of whom were disabled. So she had genuinely a need to work those fixed 2 days a week. But the NHS Trust looked at changing its policy and wanted to introduce a more flexible workforce with community nurses all doing some limited work across weekends. And that was because we've seen a changing nature in community care, and actually much of this is in the home now and 24/7. And the impact of Mrs. Dobson not working at weekends meant that there was a disproportionate impact on her colleagues who had to work across the weekends, and actually some of those were more expensive as well, so it came at a cost. So they introduced a new requirement that everybody needed to work across occasional weekends, being given notice to do so. Mrs. Dobson resigned and claimed constructive unfair dismissal because she couldn't meet that requirement, and also indirect sex discrimination. That was initially considered by the Employment Tribunal, who dismissed her claim. But she brought the claim to the EAT, and they looked at it, and it was a rather technical argument, but they essentially said and agreed that requiring women to work on weekends is potentially indirectly discriminatory because more women have childcare responsibilities than men. And so that presumption of indirect discrimination, that it's more difficult for women than men to work on weekends or certain shifts, hadn't been properly applied by the Employment Tribunal. So it looked like Mrs. Dobson was going to win. And so it got referred back to the Employment Tribunal to consider that. So on the basis that, yes, this requirement was indirectly discriminatory, it then passed over to the NHS Trust to say, could they objectively justify their decision? Did they have a good reason, and was it proportionate? And this case is interesting because we don't often get the detail of this, but perhaps in very good news for employers, the tribunal again upheld the NHS Trust decision that even though it was indirectly discriminatory, they found that it was objectively justified. And that was because that they had a good reason. They'd explained the rationale, and that was supported by the evidence. They'd engaged significantly with Mrs. Dobson and talked to her. They'd also suggested a number of compromises. So, they'd moved from their ideal position of how much weekend working there was to a reduced amount, and she had refused to compromise at all. It was interesting that the tribunal found that she did have, and this must have come out in cross-examination, that there was some limited childcare available to her at the weekends. Actually, it was perhaps easier for her to find childcare over the weekends than at other times. And so actually, in balance, when considering the needs, they supported that the trust decision was objectively justified. And so it's a really positive case because it just supports that even though there's quite a lot of challenge in this area, that actually if you have got a strong business need, that won't be overridden by an individual's needs, that it is a balancing act. And in this case, it fell on the trust's favour. She has appealed that decision, that justification decision, to the EAT, so it's not the end of the story. And so it's one that, although it turns on its facts, we'll watch with interest, because it's no doubt that it will be useful in terms of considering your approach to flexible working. And again, we didn't mention it because it's a 2027 change, but the expansion to showing that rejecting requests is reasonable. Cases like this will be really useful in terms of helping you consider the factors and the evidential trail that you'll need in the background. Gareth, I'm delighted you're back to us. I hope you can hear us all. I have covered the Dobson case, so you're perfect timing to pick up the Groom and Maritime Coast Guard Agency, and I can move the slides on when you're ready as well.
Lovely. So sorry, my laptop decided to update in a way that I couldn't stop it. So apologies to everyone for rapidly disappearing. I'm really sorry for interrupting your flows, Alice, as you were speaking and I disappeared. Anyway, back now. So the next case on our notable cases is, as Alice says, Groom and Maritime and Coast Guard Agency. And this is a case which is part heard in the Court of Appeal and is just again looking at that issue of status, and that's why we think it's important. Obviously, there is a government commitment to look at whether they have one combined level of status. At the moment, we have employee, worker, and essentially self-employed or volunteer. And this is looking at the volunteer aspects of that. So Mr. Groom was a volunteer coastal rescue officer for the Maritime and Coast Guard Agency. His membership was terminated in May 2020 following a disciplinary hearing. And he then put in issue whether he in fact was a worker rather than a volunteer. Now, the tribunal agreed with the employer that he was a volunteer. They found that that's what was described in the agreements that they had with him, that there was no automatic right to remuneration, although there was some right to reimbursement of expenses, and they didn't have control over their volunteers in relation to how they worked. So there was clearly not an ongoing commitment. The EAT have disagreed with that, and in their decision, they took the view that because there was a right to remuneration for certain activities in relation to being reimbursed or being paid a small allowance, that indicated a contractual relationship and took it away from the volunteer category. And albeit that it was described as a volunteer relationship, that wasn't seen as sufficient to actually override what the EAT saw as happening on the ground. And they found that the volunteers could in fact be classed as workers and therefore able to access statutory rights in relation to that. And there was sufficient mutuality of obligation in the relationship. Perhaps not surprisingly, the Maritime and Coast Guard Agency, who relies a lot on volunteers, has appealed to the Court of Appeal, and that case has gone part heard. It went part heard about 2 or 3 weeks ago. The remainder of the case, we will get judgment in 2026, and again, I think will include some wider assessment of status, which I think is important for all of us in when we're looking at how we manage some of these issues. The other case that I just wanted to mention is the Lister and New College Swindon case. This is a tribunal decision, but one that has now going to proceed to the Employment Appeal Tribunal, and it deals with the issue around belief and manifestation of belief. And it's a case where the Employment Tribunal dismissed the claim for unfair dismissal from Mr. Lister and protected discrimination on the grounds of belief that he brought following his refusal to use a gender transitioning student's name and their chosen pronouns. Excuse me. Mr. Lister had been employed as a teacher at New College Swindon and held gender critical beliefs, and the policies of the school conflicted with that, and he did not follow the prescribed policies, and as a result, ultimately, it was taken through a disciplinary process, and it was found that his conduct and the way in which he expressed his beliefs was objectionable in manner, and that led to his dismissal, which he has challenged. He wasn't successful in the Employment Tribunal, but has now been given permission to appeal to the EAT, and the permission hearing ruled that there were arguable points on the boundaries between belief and manifestation of that belief, which are clearly going to then form the basis of the litigation and the challenge of the decision so far, and I think give another layer again in relation to the cases that we've seen so far, and where we can see some further debate and further challenge. Those were my two case updates. So Alice, I think I can hand over to you to just do a bit of horizon scanning, please.
Thanks, Gareth. And just before we go to the Q&A, we thought it would be helpful just to look at some things that you might just want to be aware of as on the horizon. So the first relates to non-compete agreements. Now, these are contractual agreements that apply once an employee's contract has come to an end and their employment with you has ended, that set out how their behaviour might be restricted. So commonly that they aren't able to work for a competitive business, they aren't able to recruit certain senior members of staff or critical people in the team, they're not able to poach or solicit clients. Those things sort of known as post-termination restrictions. And the ones that are in question are the non-compete ones, the ones that stop somebody working for a competitive organisation. So at the moment, these are considered very carefully by the courts, and there's a lot of case law, you won't be surprised to know, that creates a fine balance between somebody's ability to get another job and to not restrain trade with businesses, organisations' right to protect its legitimate business interests. But it's being considered that that case law and the courts themselves are not enough to ensure that the balance is appropriate. And that is because some individuals may not understand that even if the contractual wording that they've got isn't enforceable and it would be too wide to be unreasonable, they don't know that. So they consider themselves bound by it, even if they aren't. And in other cases, just testing whether or not something's enforceable comes at a significant cost. And so that is a real barrier as well. So there is a consultation currently ongoing which looks at the approach to non-compete clauses, talking about potentially banning them completely and an outright ban, or some sort of other compromise position, which may mean that there's a statutory period that they're limited to, say, 3 or 6 months post termination of employment, or limiting it only to certain senior staff earning over a certain earnings limit. So I think it is an area that we are going to see change. It's probably not one that means that you need to do anything quickly about it now, but be aware it's on the horizon. And if you are recruiting particularly new staff in senior posts or where there's critical business risk, think about the restrictions that are in place and the ones that you may most need to rely on. And if you can rely on others that are not just the non-compete, that's going to be better for you. And the final thing we wanted to mention before we go to questions is whistleblowing. Again, just thinking about the big themes and topics, whistleblowing is one that is here to stay. We're seeing an expansion of that to what it covers and staff that may be able to bring claims. There has been some discussion at the government level about how to protect employees who blow the whistle further, perhaps including a new entity, a house of a whistleblowing officer or something, a governmental body that will deal with whistleblowing, so individuals will be able to raise it outside of the organisation. We may also see change, and I know a number of you are in the public sector, but to strengthen whistleblowing in the public sector. And so again, it's just one that if you're looking at your strategic HR plan, thinking about your whistleblowing policy, whether it's up to date, whether it's effective, and whether staff know about it, and is something that is definitely worth looking at, as it's going to continue to have profile over the next year and beyond. That is all that we wanted to cover today. Sorry slightly for the disruption. There are a couple I saw very interesting questions in the Q&A, but please do add some questions if you have got any. Oh, Gareth, both of these are things that I covered, but if I answer them and then if you've got any other thoughts, that would be amazing. So the first one is about managing absence when it's sporadic absence, odd days absence. And I think that's always a challenge. And of course, it may be an increased challenge if individuals who aren't currently paid for those days off will be paid for it. So my experience is that there are quite a lot of things that you can do to try and discourage absence, I suppose, where it's borderline or not genuine. I mean, one of them is thinking very much about who they have to contact when they're ill and making that perhaps slightly more difficult. I think if people can send a text message or do something to a line where there's not a real person, that's a bit easier. So it's much harder to have to phone your line manager or phone somebody in HR. So just think about that. Make sure that it's recorded properly and you absolutely are recording absences and keeping a track on it and talking to people openly when they're taking much absence, or where there's a real pattern, with odd days, Fridays and Mondays or things, is really useful as well. Thinking about what they have to do when they come back to work. Do you have some sort of self-certification form? What do they need to declare? Does someone actually read it? Does someone talk about it with them? You might not manage return to work interviews on every spell of absence, particularly if it's odd days, but is there something that triggers return to work interviews? Think about training for your line managers so they can look somebody in the eye and draw attention to how much absence they've got. Sometimes people don't even realise. And creating a culture where people are aware that absence is monitored and looked at, and they are accountable for it, can really make a difference in terms of reducing those odd days. Gareth, I don't know if there's anything else I've not covered that you would mention.
No, I think, Alice, that sounds like a pretty comprehensive answer to me. So I agree with everything you say.
The next question is a really interesting one, which is about the interaction between fire and rehire and flexible working. And so I think, so the question being, if you agree somebody's flexible working request, let's just say, for example, they currently work full time and they ask to work 3 days a week and you agree to that. If you then want to change it, would that be prevented by fire and rehire? And the simple answer is yes, it would, because changes to hours or shift patterns are things that are a restricted variation. So it's a really good question. And you'll need to think, generally where you respond to a flexible working request is a permanent contractual change. So if you are concerned that it may not be feasible in the long term, you need to think about that when you're doing your flexible working outcome. We may see an increase in trial periods, actually. You may do it for a certain time and then review it. Obviously, you can't continue that on an ongoing basis, but you might also want to think about what can you absolutely agree to and where might you need some flexibility. And I suppose, to give you an example, I work with lots of schools. You might be able to agree that somebody works 60%, but you might be able to agree that for 1 year that might be on Monday, Wednesdays and Fridays, but be very explicit that that you'll always stick to the 60%, but it can't always be Monday, Wednesdays and Fridays, and those days may need to change on an annual basis depending on the timetable. And as long as you're really clear in your outcome of your flexible working request and you've got an explicit contractual provision, then you will be able to rely on that to make the changes. So I think it's a really interesting question, and we will need to think about the outcomes of flexible working requests more carefully, because yes, it'll be harder to revisit it than it is currently, because currently if there is a really good business reason why you need to unpick it, you generally can.
Yes. And whilst you were talking, there's another question, Alice, which says, how do we stand with changing current employees' contracts? And I suppose it's along similar themes at the moment. Obviously, if you can reach agreement with an employee to change their contracts, then you're very welcome to do that. And obviously that's what's being encouraged in terms of consensual agreements. If you get to the point where you can't reach agreements and you need to impose a change, that's where this change is going to really cause you some difficulty, because you're not going to be able to impose that change by giving notice to bring the existing contract to an end and then look to re-engage the employees on different terms. So as Alice says and said earlier, thinking about where your variation clauses sit in your contract, thinking about where you might want some flex as a business in relation to your terms and conditions, and thinking about whether you build that in so it is a variation of an existing contract, is obviously a very sensible thing to be doing in terms of how you can achieve change and respond to business or organizational need. But it is going to get more difficult if you find that the contract is no longer fit for purpose going forward.
So if we've got some more tricky questions coming in, top one, and we might alternate. We'll time. So actually, the top one is what's a reasonable amount of time that a flexible working request can be extended? I imagine this is just following up my question that you might agree it for a period and then extend it. There's no hard and fast answer to that, but essentially there's no statutory provision for a trial period or to say we'll do it for a year. But that isn't to say that you can't offer that as an alternative. If someone is ultimately unhappy with that, they can appeal it. But usually I think you'd be able to justify doing that in the first instance. I think the problem is that once you have done that trial period, so let's say 6 months, and we'll see how it's going, if it is working okay without significant issues, the presumption will be that you will then need to agree to that on a permanent basis. I think you would only be able to continue to review it if there was something very particular in the circumstances that meant that was justified. I think, Gareth, I don't know if you disagree with that.
No, no, that sounds really sensible, Alice. I agree. The next question is about union recognition, and in the example given, there are around 50 staff spread across 3 unions. There's no union recognition agreements currently in place, but there's obviously membership across those unions in the workplace. And it says, could just one member of staff trigger a union recognition agreement, and would we then have could we have multiple agreements in place? I think the thresholds are under review, but one member of staff is probably not sufficient. Obviously, you want to be thinking about your bargaining units in terms of representation. And what we expect to see is the unions perhaps looking in particular sectors and looking where they can get best traction, and then looking to make requests for access to the workplace and to start talking about the benefits of union recognition and then building from there. Ultimately, it would still go to a ballot, and you would still need to meet the thresholds that are currently under review in relation to that ballot, in relation to a bargaining unit. But the overall limit of threshold is going to reduce to 10% in terms of being able to get a referral to the CAC. So if you are in a unionized environment, or an environment where unions are active, it will be worthwhile getting to grips with the various union changes that are coming, trade union changes that are coming, and that you could then work through where the thresholds sit for your organization. The other half of that, and then you could end up with more than one recognition agreement if you've got different collective bargaining groups within your workforce. The other thing to think about clearly is whether you also have your own employee staff representation groups, and whether they are strong enough and would be an answer to any union activity in your workplace if you want to resist union recognition in the long term. And thinking about how you communicate with staff, and how you build a consultative committee with staff members that has effectiveness, and staff see as a good voice, a good collective voice for them, so they don't need to go down the additional step of union recognition. The next question, Alice, follows up on
Yeah,
what you're saying about compete
yeah, two
clauses.
non-compete.
And
Yeah, do you want me to rattle through
do
that?
you want to do it?
Yeah.
All right, I'm happy to. Yeah, whichever.
Um,
Go for it.
so yeah, no, essentially, don't remove non-competes at the moment, but it is an area where we may see change. I think if you are looking to introduce non-compete restrictions in contracts for new senior staff, it's definitely worth looking at those with a keen eye, and making sure, as currently, that they're really reasonable. How long do they need to last for? What can they be as limited as possible in terms of if it's a geographical restriction that's important, or if it's the nature of the business that's important, make sure it's restricted. And think, I would say, really carefully about the other things that you can put in place that are less likely to have scrutiny. So around confidentiality, around confidential information, as I said, non-poaching of customers is much more likely to be enforceable, and as non-poaching of staff. So I would say, if you a business that really relies on non-compete restrictions, it's probably worth getting some advice to make sure that your contracts are as tight as possible, and anticipate that we will see some change around the non-compete element of those.
And it's an interesting colliding, isn't it? Because if you need to change your contracts and you want to issue new contracts, then think about the sort of way in which you
Yes.
might achieve that in terms of the foreign rehire rules that are coming. But as Alice is saying, I think the main area of focus I've talked to clients about so far is a strict non-compete, as in you cannot go to a competing business as a departing employee, are the covenants that are most difficult to enforce in any event, and probably ever reserved for your more senior people, in terms of whether it can be policed that they are going to unfairly compete when they go to their new employer, which is why there's a focus on them. The provisions won't prevent you still having non-solicitation and non-dealing clauses in relation to protecting clients, and as Alice says, non-poaching of employees. So I think really the scrutiny is to make sure what are your business interests you're seeking to protect? What does that person do for you? Are they in sales? Are they in an operational role? And then just making sure that you've got some decent covenants for a time-bound period that are properly defining the group that you're seeking to protect, so that you can have some protection and a dialogue with that departing employee, if you're concerned about what they're going to do next, or about their activities as they leave or have left. So it's not an end of covenants altogether, it's just the wider non-compete that in our ever-changing world is probably more difficult to enforce and police in any event.
Gareth, we're up against a time limit. Do you
We
think we can
are.
do 4 questions in 3 minutes?
Right.
Right.
Well,
The
we
next one
could.
is how does a 6 month limit of unfair dismissal affect fixed term contracts, for example, a maternity cover that's 12 months? So fixed at the end of a fixed term contract, a dismissal in law, once you're past that 6 months, the person will have protection from unfair dismissal. But like currently, if it's genuinely a fixed term, particularly if you've documented that in the contract that it is maternity cover, then it will be a lawful, in that case, some other substantial reason to bring the contract to an end. So you'll have your lawful reason. It's likely that you will need to follow perhaps a slightly fuller process than you might be doing at the moment to consult with the employee and particularly explore whether there may be other alternative vacancies that would be suitable for them.
Um, there are a couple more questions coming up, as you say,
Oh.
Alice, but I think we probably should bring things to a close there. Apologies
Yeah.
if we haven't got to your specific question. And apologies again from me that my laptop went in a way that I couldn't control it and decided to update in the middle of the webinar, which is really inconvenient. And thanks, Alice, for carrying on. We just popped a poll on the screen just to ask for some feedback, please, as to how you find today's webinar in relation to its contents. And it would be your feedback, as always, both through the polls and by dropping us a line, is always really helpful to make sure that we are making sure we're picking topics and delivering in a way that you find accessible and helpful in relation to this program. I think we have set our dates for our 2026. We call them Wednesday webinars now in terms of how the team manages them going forward. So there will be regular slots where we will talk about both the wider changes in terms of case law, etc., but also the Employment Rights Bill as those changes hopefully it becomes an act in the some royal assent soon and the ping pong comes to an end, and then going forward how they come into force and the support that we think you'll need, or the areas you'll need to think about as you go through that. So probably a busy year in 2026 and we have started the planning. So as I say, any feedback that supports that would be really helpful. Thank you. And I think that just comes to an end to say thank you very much for joining us today, and wish you well for the rest of the day. And if we don't talk to you directly between then and the end of the year, Merry Christmas.
Thanks.
Thanks
Goodbye.
all.